Hello, I'm Mark Brendan, and welcome to this month's edition of ProForce. This month's program focuses on a very important subject, search and seizure. Because of the content matter, we have decided to present this program in two installments. Part 1, which is coming up momentarily, looks at a number of issues, among them what constitutes a search and seizure, the concept of a reasonable man, the proof continuum, and what you need to articulate in court if you're involved in a search and seizure incident. In Part 2, which we will bring you next month, we'll touch upon the legal aspects of search and seizure. We will go over the Fourth Amendment and how it applies to you. We will discuss reasonable suspicion, articulable facts and circumstances, and the possible sources of authority. Your instructor for these two programs is Rick Fiems. Let's join him now.
Hello and welcome to this edition of ProForce. I'm Rick Fiems, Chief of Public Safety at Blackhawk College in Moline, Illinois, and I'll be your host for this month's program. For this session, we're going to be discussing a very important aspect of the security function, search and seizure for security officers. In order for you to understand the importance of this particular aspect of the job, I'm going to have to draw some comparisons. And for the purposes of this presentation, I'm going to have to compare what a security officer does with what a police officer does. And I need for you to understand why that is. In the security business at this particular point in time, with regards to this particular subject, search and seizure, there's not a tremendous body of law. There's very few places that a practitioner in this business can go to and look up cases or Supreme Court opinions, or even laws that dictate or give guidance to a security officer on which way they should go when it comes to conducting a search or seizing property or seizing people. So what we have to do in order for all of this to make sense is I'm going to have to contrast and compare what security officers do with what police officers do. What I'm going to try to help you do is appreciate the differences between these two functions. There are similarities in the way we dress. There are similarities in the terminologies that we use. There are similarities ultimately as an end result in what we do, because both police and security personnel are engaged in the business of protecting people and things. The big difference is in who pays the freight. The police function and the security officer function, despite the fact that they're playing in the same arena, play by completely different sets of rules. So let me start out by explaining to you why and how police officers make decisions with regards to search and seizure for the things that they have to do. Let's start with what cops do. A lot of what a police officer does, day to day, day in, day out on patrol, when they have to decide whether they're going to search and how intrusive that search is going to be, how far that search is going to go. A lot of what they use for guideposts is dictated by regulations from the outside. In other words, from outside of the department, from outside of the law enforcement business. These are the sources for these outside guidelines are things like court decisions, either local courts or in some instances all the way up to the Supreme Court. Variations and differences in state laws. The way laws and statutes were written sometimes give police officers as public employees, as agents of the state, different rules to go by, different standards to meet, and different ways that they can respond to a particular situation. Depends on the law. The Supreme Court, when they come out with a decision, oftentimes has a sweeping effect on how police officers, peace officers across the country engage in the business of practicing their craft. These are the outside things. Sometimes the Attorney General in a particular jurisdiction for a particular state is asked an opinion about how should we do this in relationship to a change in the law. How should we respond to this? A perfect example of that was the state of Iowa just passing laws about what kind of entertainment can be in certain bars and not telling the various state's attorneys how that was to be enforced. In essence, what they've done is pass a law that has no teeth in it as of yet. They have a lot of places outside of where they work and exterior to their law enforcement functions. Security officer actions, on the other hand, depend to a great deal upon the service arena that they work in. In other words, what a security officer does with relationship to search and seizure depends upon the specific and oftentimes particular kind of security that they are engaged in. So what we're talking about is the differences between school security, either at the high school or even at the college level, mall security, completely different way of providing a service and doing a function. Housing security is different. Industrial security is different. Hospital security is different. Theme park security is different. Merchant security is different. The bottom line is, what is a good security practice at a local high school or at any high school may be a horrible security practice at a mall. So it depends upon where something falls within that particular frame of reference for that particular assignment. With a police officer, it depends upon where something falls on the scale of proof. Police officers are oftentimes trained to do what they do on what we call the scale of proof, or the proof continuum. It starts out at one end with what we call mere suspicion. An officer is just kind of suspicious about something that somebody's doing. What they do is they watch this person. They just keep them under observation. And if nothing else comes of the watching, of the observation, they move on to other things. They've done what they're required to do, what they wanted to do. The next step up the ladder, or next point along the scale, on this proof scale, is an articulable suspicion. In other words, the officer can put together a reason why the person's conduct or why the circumstances would give them cause to stop this person. That is known as a Terry stop in law enforcement circles. And maybe a little explanation will help here. It's named after a case called Terry versus Ohio. In this case, a police officer was off duty in a downtown area, just down there shopping, as I recall, with his spouse, and he was watching the activities of some men on a street corner. Now, what they would do is they would huddle up together and talk, and then one would break off and he'd go look inside a jewelry store. He'd come back and he'd talk with the group, and another one would walk away and look in the jewelry store. All four of the men did this. The officer watching that had the feeling there's something going on here. These guys are casing this place. He walked over and he identified himself as a police officer, asked them for identification, asked them for what they were doing, and because there were four of them there and because he feared for his safety, he frisked them. And in the frisking of one of the individuals, he found one of them to be possessing a gun. He arrested him for possession of the firearm. The person filed, naturally, an appeal saying there was no reason for the officer to search him, and the Supreme Court said not so fast. All of those things put together gave that officer enough of a reason to check those people. And with that articulable reason for checking them, that officer then had the right to protect himself. So the Supreme Court said that's good. The next movement up the scale then is what we call PC, probable cause for an arrest. That's the next thing that a police officer uses. Probable cause, the definition of probable cause, as is applied for police officers once again, works like this. It's those facts or circumstances that would cause an ordinary, reasonable, and prudent person to believe a crime had been or was being committed. Now, probable cause is what an officer uses to arrest. That's the next point in the scale. Just kind of review. Mere suspicion, articulable circumstances, probable cause. The next step along the line comes just a little bit over halfway down our scale of proof. It's called preponderance of the evidence. It's a civil thing. It's not really criminal, but it's 50.1%. In civil court, if I sue somebody and I go to civil court and I'm 50.1% right, I win. That's in a nutshell. That's kind of an oversimplification, but that's what we're talking about by a preponderance of the evidence. If I have the most evidence and I prove by a preponderance of the evidence my claim, I win. The next point on our scale is proof beyond a reasonable doubt. Now, that is the standard that must be met for somebody to be convicted of a criminal act. Proof beyond a reasonable doubt, sometimes referred to as 99% certain. 99%. At the very end of that scale is absolute certainty. Absolute certainty in a criminal case is extremely rare to find. Most of the time it falls somewhere between the two extremes, between mere suspicion. It's got to be at least probable cause for the officer to make an arrest. And then what we have to establish in court is proof beyond a reasonable doubt that the person we arrested committed the offense. Those are actually, as vague as they may sound on initial introduction, for the purposes of searching and seizing, those are pretty clear guidelines. That's pretty solid stuff to go by for a police officer to make a decision as what they're going to do.
Wait a minute, ma'am. Wait a minute. I need to talk to you. Can I get some assistance, sir? I think this lady stole something out of my store.
Did you see her steal anything?
I didn't take anything.
Well, I didn't.
Back on the security side of the fence, I'm afraid the situation isn't quite that easy to understand. Security guidelines are not that clear. As a security officer, you have to remember that the source of our authority, basically, absent legislation, ordinances, or some type of laws to the contrary, basically the authority that a security officer has looks like this. It's either the same as any other citizen, that's the way that it is in my home state of Illinois, or their authority comes from the employer, which is another possibility, and for that we look back to job descriptions and other things. It can come from the client, which is another possibility. Our client may request of us to provide them with certain services, and if the statutes and the guidelines and the regulations permit it, certain authority can derive from that, or it comes from the circumstances. That's probably where most of the stuff that we're going to be doing as a security officer, that's where most of our authority is going to draw from, is it's going to depend upon the circumstances. So before we go any further, understand that what you need to know is, depending upon where it is you are working, depending upon the state that you function in right now, you need to research, you need to ask questions of the county attorney or the state's attorney, whatever the case may be. What exactly are your authorities as a security officer underneath state law? And after you've done that, it wouldn't hurt for you at all to look at county ordinances to see if there's any guidance there, and then take it the little extra step and see if there's anything under local ordinances that create some kind of special authority or special circumstance for security people. That was quite common years ago when merchants used to hire retired police officers to be what they called merchant policemen. They had their authority came from a local city ordinance that allowed them to be the ones to go around and secure these businesses after hours. As a security officer, basically and in a nutshell, you need to base what you do on any search and seizure action that you undertake on what is known as the concept of a reasonable man. Now let me explain what that is. Oftentimes when I get to this point in teaching this particular segment, I like to write the word reasonable up on the board and spell it R-E-E-S-U-N-A-B-U-L-L, and that's so people can remember it. Everything that you do as a security officer needs to be done reasonably. But when we're talking about the area of searching for something or even seizing something, you have to be very, very careful and be very, very ready to explain clearly and in great detail why you did what you did. It's very, very important here. The trier of fact is going to rely on that. So where do you go? You have to follow the rules, and they come from this place. Job description. What does your job say you're supposed to be doing? When you've read your job description and understand what's going on in there, look towards your post orders. What are your orders for that post if you're standing a post or working a specific patrol? What are the specific requirements there? Look at the guidelines laid down either by your employer or by the client as far as what kind of things they want you to do. You have to be able to go back and look at some source of authority to keep you from getting in trouble as a security officer. You have to look to some other place to provide you with direction.
Hi.
Hello. I was wondering if you would mind stepping into the security booth and disclosing the contents of your purse.
Oh, sure, no problem. If you'll hurry through it, I don't want to be late.
It'll only take a minute.
Okay.
Thank you for your cooperation. If you wouldn't mind, please opening your purse so I could examine the contents.
Okay.
All right, that's good. Thank you.
Thank you.
Again, thanks for coming into the security booth, and thank you for your cooperation.
You're welcome.
Have a good day.
Thank you.
As you can see from the scenario, when things work like they're supposed to, it's pretty easy. And that's probably what's going to happen most of the time. You're going to make a request, the request is going to be complied with, everybody's going to be an understanding of what's going on there, and it's going to work pretty smoothly. It's not going to always work out that way.
Good afternoon, sir. Do you mind stepping inside the guardhouse and disclosing the contents of your bag?
No, I will not. I don't have time for this.
Sir, this is in accordance with company policy. If you'll note the sign posted there on the gate. So again, I request your cooperation.
No, I won't.
Sir, then I
What
have no
you need to
alternative
keep
but
in
call my
mind is that regardless of the situation, once you exceed the scope of your employment, you're on very thin ice. Say it another way, you're in very dangerous ground. As long as you stay within the scope of your employment, if you do what you are supposed to do, as you're required to do by your job description and by your company rules and regulations, the company must back you.
Good afternoon, sir. Do you mind stepping inside the guardhouse and disclosing the contents of your bag?
No, I will not. I don't have time for this.
Sir, this is in accordance with company policy. If you'll note the sign posted there on the gate. So again, I request your cooperation.
No, I won't.
Then I have no alternative but to contact my supervisor and request his assistance. Would you please wait as I contact Mr. Smith?
Look, I'm not waiting. I'm out of here.
Sir, please wait. I have no alternative but to report this. Base, this is Station 2 parking lot.
Sometimes that's the way it happens. And when those kind of situations pop up in the performance of your duties, that's where you need to remember that what you have to do out there is stick with that job description. And remember this, bottom line, your primary function, observe and report. Don't get caught up in a scenario where you're going to be asked or forced to be in a situation where it's going to look like it's anything more than that. Stay with those guidelines and you're going to be fine. Exceed the scope of your employment in any way, but especially with search and seizure. You're going to be hanging out there by yourself. Your employer is not paying you to do that. You're on your own when you take that big step to go beyond the scope of your employment. Protect yourself by following the rules. Having mentioned search and seizure now kind of set the ground rules for you and got things hopefully in some kind of a perspective. The police have pretty clear guidelines. Security doesn't. We have to look to our specific function. Let's get now to an understanding of what it is we're talking about. When we search, what we're doing, searching is defined as looking with a purpose. Normally when we search for something, the purpose behind the search is to uncover one or more of the following types of things. We are either trying to find evidence of a crime, fruits of a crime, instrumentalities of a crime, or contraband. Evidence is defined as anything that tends to prove or disprove an alleged fact. We oftentimes get caught up in the security business of thinking what we are about is going out there and proving people guilty of criminal acts or proving a breach of security or proving a violation of the law or proving that something wasn't done where it was supposed to be done or something was done that wasn't supposed to be done. As a matter of fact, when we gather evidence, when we search, we also have to pay attention to the evidence that proves people innocent. We have to look for those things, those factual things that either prove or disprove an alleged fact. It's not all one-sided. If the evidence is there that clearly exonerates somebody, then it's our obligation as professionals, as ethical people, to make sure that that evidence finds its way into the trier of fact, whoever that might be, as well as the evidence that's incriminating. We can't overlook that. When we're talking about fruits of a crime, what we're talking about there is the things that people gained as a result of committing the criminal act. Articles that were stolen, sometimes money, sometimes jewelry, sometimes videotapes, sometimes cigarettes, anything, the loot, as it's called sometimes, that is obtained by the person who commits a criminal act. The instrumentalities of a crime are those things that were used in the commission of an offense. Could be a crowbar, could be a screwdriver, could be a key, if that's how somebody gained entrance to something. Could be a lock pick. Any one of those things are things that people use to commit a criminal act that point to the commission of an offense. We're looking for those as well. The last one then is contraband. Contraband is defined as anything that we just shouldn't have, either by regulation, by ordinance, or by law. The average citizen has absolutely no business with a hand grenade. That's contraband, or a rocket launcher or something like that. Drugs, controlled substances, are contraband. In certain specific work areas, certain things that normally wouldn't be contraband, like maybe matches in a paint factory, they're contraband there. So it depends upon where we are sometimes, the definition of what contraband is. The best definition is just things that for whatever reason we're just not supposed to have. For our purposes now, since we're concentrating now on the security side, each individual search that we undertake is going to be looked at as an individual moment in time. Remember what I said earlier, there is no body of law. There is no place to go look up and look at a scale and see if we're doing things the way they're supposed to be done based on the evidence. So what the trier of fact is going to look at is they're going to rate what we did as far as searching on how intrusive that search is. Now, intrusiveness as a concept is something that is relative to the security arena. Do you remember earlier when I told you that the security at a school may not be good security at a mall and that kind of thing? The security function, for example, at a junior high school or high school of doing locker searches, that is a concept that is perfectly acceptable in a school setting, because the triers of fact who listen to those types of complaints have said that that's not intrusive. That's acting as a responsible parent would act. We expect school officials, principals, and administrators to do that kind of thing. So that kind of a search is allowed, even encouraged in that particular arena, in that particular setting. That same search conducted at a work locker, now we've got a different arena.
Excuse me, ma'am. Do you mind if I take a look at what's in your locker?
Oh, yeah, sure.
If the locker that is being searched at work has not been set up to have an expectation of privacy, then we're okay. Now let me explain what that means, because this is the subtle little nuances that happen when we're talking about how a search is conducted. If in the place where somebody works during the orientation program or the orientation process, the employee is told, here's your locker area, here's your locker, you can put pretty much anything you want to in your locker, you can put your own lock on it, we don't care much about what's going on inside your locker, that's kind of yours to use however you want to, just don't bring anything nasty in there. If an employer does that, what they are creating, and once again the key word here is reasonably, they are creating in the minds of that employee the reasonable expectation of privacy. Whatever they put in that locker, or in that desk for that matter, or in that company vehicle, is okay with it's theirs. It's their locker, it's their desk, it's their vehicle. That expectation of privacy is created. But if, on the other hand, the company makes it quite clear to an employee when they first hire them, here is the locker we're assigning to you. It's yours to use, but it's our locker. And we're going to provide you with a lock that you'll have the combination to, but it's our lock. And oh, by the way, we conduct unannounced and frequent locker searches, and if we think that there's something in the lockers that shouldn't be in there, we're going to check it. That removes that expectation of privacy, as long as that is in fact done on a regular basis. To say it and not do it sometimes creates another expectation of privacy in the mind of the locker user. It's those subtle little things like that in the security side that we have to be very careful of when we're conducting a search. Generally, the more intrusive a search is, the closer a trier of fact is going to look at the circumstances. Which gets back to the point that I made earlier. You have to be ready to explain why you did what you did.
I approached him, questioned him as to what he was doing there.
What did he say? What did he say? And what did you ask him? And what did he say?
I first asked him what he was doing. He did not reply at that time. I realized he was not an employee of the company.
You have to be able to articulate to a trier of fact that this is what I saw, this is what happened, here are the circumstances, that's why I did this. In order for you to do that and do that in such a way that you're going to protect yourself and protect your organization, have the backup documents ready. You're going to have to know and understand the laws that apply in your particular jurisdiction with regards to searching and seizing as a security officer. You're going to have to know those work rules and regulations inside and out. You're going to have to understand those post orders. If you're working a fixed post that requires you to search cars periodically, you need to understand that. You need to know what that job description says about your function as a security officer in that setting, and you need to understand if there's any special orders or anything that you need to know that came from the client. You must be able to articulate that stuff. And probably the most important thing that you're going to have to articulate to a trier of fact when it comes to you doing this are the following 2 points. You have to be able to state and be able to back up that you were in a place you had a lawful right to be. That's first. Second, what you did in that place was a reasonable thing to do. If you can remember those 2 things about searching and seizing as a security officer, you're halfway there. It's going to be a lot easier for you to do your job. Were you in a place you had a lawful right to be? In other words, were you staying within the scope of your employment? Were you on company property? Were you on client property? Were you doing your job the way your job description said it was supposed to be done? And then, did you do what you did in a reasonable way, in compliance with all of those things that were listed for you? That's how it's going to be looked at. If the answer to those things is yes, you're fine. You're fine. You're not going to have much more explaining to do beyond that. The person that had the contraband or the fruits of a crime or the instrumentalities of a crime, that person's going to have some explaining to do. While we're talking about searches, I need to clear up a few things for you as well. I get asked this question by security officers quite a bit. If they are walking around on patrol, driving around on patrol, and they see something that's contraband or they see something that looks like evidence of a crime, does that constitute a search? The short answer is no. Things that are found out in plain view, seeing something in plain view is not searching, it's just discovering. It's finding. But plain view means just that. It means plain view. That means you can't lift up a blanket or a tarp or anything like that to see under something. You can't move something out of the way so that you can check behind it or alongside of it. It has to be in plain view where you can see it. But on the other hand, lighting up a darkened place using a flashlight is not intrusive. In other words, illuminating something is okay. That's not searching. If all you did was flip on a light and there it was, or if all you did was walk into an area, hit it with a flashlight, and there it is, that's not a search. That's just a discovery. We passed right up search and went right into seizing. So hopefully that clears up 2 of the more common questions about, can I get away with that kind of stuff?
When it comes to search and seizure, remember these important elements. First, be ready to explain why you did what you did. Also, be familiar with the laws in your jurisdiction. Know your work rules and regulations. It's also important to be familiar with your post orders. Know your job description, and remember any special orders that your supervisor or manager has conveyed to you. That concludes Part 1 of our program on search and seizure. Join us next month for Part 2. Until then, I'm Mark Brendan. Now stay tuned for Security Works, which is coming up next.